Well, hello there. My name is Austin Nowakowski, and I am the owner of Nowakowski Legal PLLC. We are Washington's inheritance lawyers. We assist our clients here in Washington with the probate administration of estates, in estate planning matters, and in instances where litigation is necessary in inheritance or estate disputes. I am putting together a series of videos as it pertains to probates in Washington for purposes of informing potential clients or individuals that are in need of becoming a personal representative or an executor to an estate. In this first video, I plan to provide a general overview of probate and to simply answer the usual questions that I receive from a potential client when they call my office and they inform that they've just lost a loved one and they have questions about probate. Those questions are usually first, what is probate? Second, when is a probate necessary? Third, who is supposed to act as the personal representative or the executor of a probate? And fourth, where do I file for a probate? And fifth, and usually the one that is prompted them to call me is, do I need to hire an attorney for purposes of pursuing this probate? So with that being said, let's go ahead and get started. So the first question I'm normally asked is, what is probate? And probate is very simply the legal mechanism through which a deceased individual's assets and debts are addressed and resolved. So what does this mean? Basically, it means that probate is a legal action that is filed in a court that is intending to simply appoint an agent, or more commonly known as a personal representative or an executor, as the deceased agent to resolve all his remaining assets and debts. So what will happen is when somebody passes away, a person will seek appointment in a court of law. That person will be appointed, and then that's that person's job to locate all of the assets of the deceased, to determine if there's any debts of the deceased, and to use the individual's assets to resolve the debts. Once the debts are resolved, those assets are then transferred to all of the heirs and beneficiaries of the deceased. And that is the personal representative, executor, administrator's job. And I keep on saying personal representative, executor, administrator. These are all interchangeable terms, but people hear different things and they don't know which one is which, so I just want to make sure that it's clear. A personal representative is an executor, is an administrator. So if I say any of those terms, just remember they all mean the same thing for our purposes. So anyway, the personal representative or the executor will be appointed, and that is their job. Their job is to basically resolve all of the worldly assets and all the worldly debts of the deceased on their behalf, because obviously the deceased person is no longer here to do it themselves. If there is a will, the executor will be bound by the will and will have to adhere to the terms of the will. If there is no will, then you go by state statute, which is pretty much what you think it would be. If there is no will and the deceased had a spouse, the majority goes to the spouse. If the deceased did not have a spouse, then if he had children, it goes to his children. If there are no children, it goes to parents. If there are no parents, it goes to brothers, and so on and so forth if there is no will. Obviously, if there is a will, you follow the will. So that's basically the purpose. So now that we know what a probate is, the next question that usually follows up on that is, well, when is a probate necessary, and do I need to pursue a probate for my loved one's estate? And to answer that question, in Washington, a probate is generally necessary when you have what is called a solvent estate. So what is a solvent estate? In Washington, a solvent estate means that a deceased individual, they passed away owning more than $100,000 in assets, or they owned real property in Washington at the time that they passed. Real property is a home or land or something of that nature. So why does this make sense? Why does having more than $100,000 in assets or real property, why do you think that would necessitate a probate? And the answer is, let's do real property first, because that makes the most sense, is real property can only be transferred through a deed and can only be transferred by the owner. Well, if the owner's passed away, then how are they going to hire a real estate agent? How are they going to sign a deed, etc., etc., etc.? The answer to that is that a probate appoints an executor, and that executor then has the legal authority to sign on behalf of the deceased for the deed or retaining a realtor or listing and selling the property and all those kind of things. So a solvent estate with real property would likely require a probate so that an executor can be appointed who can list and sell the real property and or sign the transfer documents for purposes of resolving that real property. Um, on the side of assets, having more than $100,000 in assets, the reason that a probate would likely be necessary is because those assets would likely be bank accounts. And banks will not allow a person to simply just access the bank accounts when somebody's passed away unless those banks can verify and confirm that the person that they're releasing those assets to is the appropriate individual. So, how did they determine who the appropriate individual is? Again, the executor. So, the executor would go to the courts, would seek appointment, be appointed by the court as the executor. Then the executor would go to the bank and they would show the court documents, and that bank would say, "You are the person that we need to release these funds to." So, generally speaking, a probate is necessary when you have real property or when the deceased had more than $100,000 in assets. So, now once a client has learned whether or not a probate is necessary, and assuming they've just learned that it is necessary, the next question that I always get is, okay, well, who is supposed to bring the probate? Who is supposed to be the executor? Personal representative, administrator, again, all interchangeable. And the answer to that is it can be one of two things, and it depends on whether or not there is a will or if there is not a will. If there is a will, it's very simple. You simply go to the will, and 9 times out of 10, actually more like 99 times out of 100, the will have listed the choices to who's going to act as the personal representative as made by the deceased themselves. In the will, it'll say, this is the first person I want to be appointed as a personal representative. If that person does not want it, then I want this person. If that person does not want it or cannot serve, I want this person. So you would look to see that in that will who the deceased individual had nominated first, and then you would see if that person wants to act. If that person does, then that person would likely hire an attorney, and that attorney would then take the will to the court, file the appropriate documents, and get that person appointed. If that person does not want to be appointed, then you go down the list until you find one of the people on that list that does want to be appointed. If there is no will, or if nobody on the will that is nominated to act as the personal representative executor wants to serve, then you go by state statute. And state statute essentially says anybody that's interested in the estate can technically pursue the probate and seek appointment, but the court has preferences. And the court's preferences should be basically in relation to the deceased. Whoever's more closely related to the deceased should be the preferred individual to be appointed. The first person that the court would want to have appointed would be the spouse of the deceased. Makes sense. That's probably the person who everything's going to, or the majority of things are going to, so you might as well have that individual appointed. If there is no will and the spouse doesn't want to serve, or there is no spouse, then you go to the children of the deceased that have reached the age of majority. If there are no children, then you look at the parents of the deceased. If there are no parents, then you look at the siblings of the deceased, and so on and so forth. So, when somebody is looking to who is going to be appointed as the executor, the personal representative of the estate, first, look at the will. If there is no will, or if nobody in the will wants to serve, then whoever is in closest relation and wants to serve. Whoever ends up serving should go hire an attorney, and that attorney will then get them appointed so that they can be appointed as the executor, personal representative, and that they can start to administer the estate appropriately. So once it's been determined who the personal representative, executor, administrator is going to be, the next question is, okay, well, where do we go and file for the probate? The answer to that question is pretty easy and straightforward. If the deceased individual was a resident of Washington at the time they passed away, or if they own property in Washington, you will need to file for the probate in a Washington Superior Court. Washington statute allows for you to file in any county, regardless of the county in which the deceased passed away. So this is advantageous for personal representatives that might reside in one county and it's a different county than the deceased, and they'd rather hire an attorney closer to them, and if they have to go to court, not have to drive all the way across the state. So in answer to that question, in Washington, a deceased individual that resided here or owned property here, you can file in any county for the probate. There are some caveats to that. If a dispute arises or if any interested parties wants to change the venue from the county that the action is filed in into the county in which the deceased resided, they can do so. But this very rarely occurs, and it only occurs when there's a dispute. So, for the most part, if a deceased individual passed away in Washington or they own property in Washington, you would file for the probate in any county in Washington um, in one of the superior courts. So, after all those questions, the last question that I normally get from potential clients is, well, do I really need an attorney to file this probate and to get appointed as the personal representative? The answer to that question, coming from me, an attorney, is probably pretty obvious, but yes, I absolutely believe that you should hire an attorney to assist with probate. The reason being is that probate is a legal process. You do need to file multiple documents with the court. You do need to adhere to multiple notice requirements. There are statutory obligations that need to be adhered to. And when you are appointed as the personal representative to the estate, you are given what's called a fiduciary duty, which gives you a heightened legal standard, which if you don't know what you're doing and if you make certain mistakes, you could be held liable for those mistakes, and it's never a pretty thing to deal with. I have a lot of clients that come to me after they've already initiated the probate on their own and something happens and they come to my office 6 months after they've already been appointed and they say, hey, help me. And you look at the probate and there's just things that need to be fixed, and it ends up costing them more to fix the issues that they caused because they didn't hire an attorney to begin with than it would have cost them if they just hired an attorney to start with. The best example that I always give my clients when they ask if it's a good idea to hire a probate is I tell them, hey, look, let's think about this some other way. Like anybody can technically fly an airplane, right? But I'd rather have a pilot sitting in the cockpit than me flying the airplane. So same with whether or not you should hire a probate attorney. Anybody could probably maybe figure it out how to go through the courts, but you would absolutely want a professional to do the work for you to make sure that it's done right. So my answer to that question is yes, I do 100% believe that you want an attorney when you are pursuing the probate process. So that's it. Those are the 5 most common questions I receive from potential clients who are calling about Washington probates to my office. Um, I plan on providing a couple of more videos regarding probate, a little bit more in detail as to the process and specific things to expect. But I wanted to provide this video because it kind of provides an overview as to what probate is. And like I said, it answers the most common questions that I normally receive from potential clients. If you or anybody that you know is potentially going to be appointed as an executor or has lost a loved one and is trying to figure out how to handle the estate, please feel free to call my office. We would be happy to provide a free consultation and see if we can assist. And if it's a matter in which we are unable to assist, we would at least be able to hopefully point you in the right direction. So other than that, thank you for taking the time to listen to my video, and I look forward to providing more in the future. Have a great day.